friends, how are you? Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, we will discuss an important concern about bail concerning the cybercrime. As you know that it is not easier to get a bail more specifically in a case concerned with cybercrime. But despite of that, we have to understand the certain fundamentals so that we could easily put up our case for bail without leaving anything. And apart from that, if your pleadings are dominant, your arguments are specific, and it is pinpoint, definitely you could chalk out a good case for the bill. As far as offense is concerned, it might be a serious concern from the prosecution point of view. Because whenever you are indulged in a cybercrime, the prosecution used to submit that the offense is serious, and that's why arrest is done. And if the bail is given in that scenario, negative message will be in society. So, looking to the fact and circumstances, the bail is to be rejected. But do we think that the prosecution is right in its approach? The answer is in negative because the basic rule is of bail, not jail. And even though the accused is arraigned in BNS, in cybercrime, the said protocol would prevail. Means the accused deserve a bail, bail is rule, jail is exception. But I want to clarify that whenever you are indulged in any case and maximum term of imprisonment is less than 7 years, in that scenario, there is no need to move for anticipatory bail, even for question. The concerned police is bound to serve you a notice as per section 41A of CRPC or as per section 35 subclause 3 of BNSS. If notice is not given and the authority is going to compel you to join the investigation and come at PS, you may abstain. And if the notice is not going to be given to you, simply you may issue a notice to the concerned police either individually or through counsel. But despite of that, the concerned police is not going to comply with the legal position. I'm going to specify more specifically the legal position laid down by Honorable Supreme Court in its judgment Arnesh versus State of Bihar, wherein Honorable Supreme Court observed that if the concerned offence is punishable with imprisonment up to 7 years, the authority is not supposed to do arrest automatically or in the mechanical way. If the accused is cooperating in that scenario, Section 41A CRPC notice could be given and the arrest could be avoided. But if in the routine manner the arrest is going to be done, in that scenario, the erring officer would be responsible. So basically, we have to understand that even though the offense is a cybercrime, but if the imprisonment is less than 7 years, in that scenario, the police could not effect the arrest on automatic basis. They have to serve you a notice as per section 35 subclause 3 of BNSS. And if you are not cooperating, you are evading the consent notice, in that scenario, the arrest could be effected. Now the important question arises: what we can do if the notice is not given? What you can do? You could go for anticipatory, and even you could address the honorable court on the said issue. I am saying about honorable high court as per the protocol of section 5 to 8 of BNSS. So simply we are having the remedies. It depends upon you whether we are going to proceed in the orthodox way or we are going to proceed as per the protocol of law. If your approach is emotional, it is orthodox, then you could not be succeeded. So simply you have to see the cause and effect. So if the concerned authority is going to violate the law, do you think that it is justified that we are going to surrender? You are not supposed to surrender. You are not supposed to cooperate if they are going to violate the law. If they are going to violate the law, you may address the honorable court in which manner the violation is done. For example, if the imprisonment is up to 7 years, as I told you, and there is no notice of section 35 subclause 3 of BNSS despite of demand, in that scenario, it is a legal non-compliance, and you may address the Honorable Sessions Court regarding the said issue concerning the anticipatory bail. Regarding this, you may rely on section 482 of BNSS. You got the point now? So basically, in that case, the concerned girl submitted that the concerned boy used to stalk me or used to threaten me regarding marriage, and he entirely cleared my photographs without my consent, but there is no recovery of the consent photograph. So if the statements are made, but to corroborate the statement, there is nothing on record, and apart from that, the statement of the concerned girl or prosecutrix is highly inconsistent, then we could have the benefit. And apart from that, the matter is to be reported to the concerned police immediately. If there is a delay and delay is not justified and there is no plausible explanation from the concerned prosecution side, in that scenario, we could have the benefit. And apart from that, she may allege that the concerned messages are vulgar, but there is nothing on the record to sustain the same. And apart from that, the messages which are termed as vulgar are not recovered from the mobile phone of the concerned accused, then we could have the benefit. So everything depends upon the nature, quality of evidence. If the evidences are not available on the record, if available, but evidences are highly inconsistent, there is lack of corroboration, then we could have the benefit. So ultimately, the concerned boy got the bail from the consent court. So we have to emphasize on the compliance of section 480 subclause 3 of BNSS, and apart from that, we have to challenge the arrest on ground that it is done in violation of section 35 subclause 1 subclause B of BNSS. So if by the bare perusal of record it is evident that you are not tampering with the evidences, you are not disappearing the evidences, you are not going to induce any person who is acquainted with the fact not to depose against you, there is no chance of yourself to flee away from courts of justice, you are not committing any offense, so you always cooperate with the investigation. So in that scenario, you could chalk out a good case for bail before the consent court. And apart from that, the filing of charge sheet is also one of the most important ground to have the bail plea in your favor. And apart from that, if you are not having the criminal antecedent in that scenario, the chance to get the bail would be on dominant side. If your arguments are unspecific, it is highly unstructured, it is highly unoriented, you could not be succeeded. And last but not least, if there is any FIR, I request all of you to give the plausible explanation, because if you're going to argue your case in simple manner, my lord, I have been falsely implicated, there is nothing on record against me, you could not be succeeded. You have to specify why you are involved in this case. You have to specify the ulterior motive on the part of prosecution, and apart from that, you could specify the non-compliance of the legal provisions so that we could easily submit our case for the bail. In simple way, we could not be succeeded. So simply we could say that we are supposed to give the plausible explanation of the allegation. We have to see whether the FIR is delayed or not. If it is delayed, we could have the benefit. And apart from that, the custody period is also important. And in addition to this, if no investigation is pending, no recovery is pending, and charge sheet has been filed or submitted in the case, then the chance to get the bail would be on the dominant side. So simply observe all these things, keep all these things in your mind while drafting or while pleading the bail plea before the consent court, more specifically when the matter is concerned with a cybercrime.